Hi guys, welcome to my channel, The Legal Affair, with myself, Attorney Bay. As always, we talk all things law, and our conversation today is on companies. Please, of course, do remember to subscribe to our channel on YouTube, The Legal Affair. You can also follow us on social media, The Legal Affair. You can also follow me on TikTok and Twitter at attorney_bay. That's at attorney_bay. So when it comes to companies, we know in South Africa, the main piece of legislation or law that regulates the companies rather, is the Companies Act. There are, of course, other laws, but perhaps the most important is the Companies Act. Now, we do also know when it comes to the company registration process, the CIPC is the body or the entity that regulates the opening up of companies. So when you do engage with the CIPC, you can either open a company yourself, meaning directly with the CIPC, and in the alternative, you can have a third party open a company on your behalf. When it comes to opening up companies, I think it's actually better suited that you open a company yourself, because in many instances, when third parties open companies, they tend to charge quite exorbitant fees. So important also when it comes to the company registration process is a name reservation. I think it's of assistance that when you think of a name for your company, you think of at least about 3 or 4 names, so that if it so happens that the first name that comes to mind is already a registered entity, at least you have some other alternative names that you have already thought of. So in the South African context, we know that when it comes to companies, there are various types of companies that you can open. So we know there are public companies, there are private companies, we know that there are state-owned entities, there are personal liability companies, there are external companies, and there are also non-profit companies. So a private company is a company that is a private company. The shares of a private company cannot be sold to members of the public, and the shares of a private company cannot be transferred from one person to another or from one entity to another. Now, public company is also a profit company, and with public companies, the shares of a public company can be sold to members of the public, and they can also be transferred from one person to another or from one entity to another. Now, state-owned entities are, of course, entities that are owned by the state. As an individual, you can't open up a state-owned entity. It's only the state that owns state-owned entities. Then we have non-profit companies and external companies. Now, a non-profit company is a company that is set up to have some sort of public gain or benefit. So it can be cultural, it can be social, it can also be communal. When it comes to external companies, these are foreign companies, in other words, companies from other countries that generate profits in the Republic, and also they operate as a business in South Africa. So when it comes to opening up a company, I think it's quite important to consider the various types of companies that you do open, and you are mindful of the type of company that you open. The last company that you can open up is, of course, a personal liability company. Now, as is implied in the name, personal liability companies are companies where the directors of that particular entity can be held personally liable. So the directors are jointly and severally liable for the liabilities of that particular company in question. So there used to also be closed corporations. You can't open up a closed corporation now in South Africa, but if you do have a closed corporation that is in existence, it does of course continue to be in existence. I think it's important that when it comes to various types of companies, just making a decision on the type of company you want to open, consider what you think, what is better suited as a company, specifically in the short term and in the long term when it comes to the type of company that you want to open. So in the company registration process, when you do register a company, the company also is required to have an MOI. So the MOI is also known as the Memorandum of Incorporation. So what the MOI does, it really sets out or steers that direction that a company wants to move in. So in some instances, the MOI is very flexible, and in some instances, an MOI is not flexible. But the MOI, in its essence, sets out what a company can or cannot do. Are there certain prohibitions that a company has? Are there prohibitions that the directors of a company has? Is there a limitation on the number of the shareholders the type of company will have, on the number of shares the company will have, on the various classes of particular shares? So the MOI has the intention or the purpose to really be a guide on the particular company in question. I do also know that when you open up a company, the CIPC also has a standard template for an MOI. So if you opt to use the MOI for the CIPC, I think it does help or is of assistance that you actually just go through it. Does it reflect the intentions that you want to have for your particular company. Do you want a flexible MOI, or do you not want a flexible MOI? So those are some of the considerations that you have to bear in mind when it comes to the MOI and the direction that the MOI wants to move. Do you want to place limitations on a company? Do you want to place limitations on the directors of the company? Are there any limitations like to place on the shareholders of the company and the rights of the particular shareholders, or how, like, what a company is prohibited to do or what a company isn't prohibited to do. So there are quite a few things that you'd want to go through when it comes to the MOI, just to ensure if it actually reflects what you want for your particular company in question. Now, in the company registration process, we also have pre-incorporation agreements. A pre-incorporation agreement is an agreement or contract that a company that isn't registered can conclude. So the purpose or the intention of pre-incorporation agreements is they allow a company to actually execute on some tasks or some duties that they would want to do so. And when it comes to pre-incorporation agreements, they allow a company to actually start functioning before its registration. I think with the pre-incorporation agreements, it's important to try and limit the number of directors that can actually conclude pre-incorporation agreements on your behalf. So I don't think you want all the directors in your company to actually be able to conclude a pre-incorporation agreements. I think only a few directors, and just to allow the company to actually to purchase items if it wants to do so, to sell items if it wants to do so, and so forth. So pre-incorporation agreements are quite important, and I think when it comes to pre-incorporation agreements, limiting the number of directors who can conclude pre-incorporation agreements can be of assistance for companies. Now, lastly, when it comes to companies, very important is directors. Now, directors, of course, do differ quite substantially from shareholders. When you are a shareholder for a particular company, you, of course, do own shares. If that particular company pays dividends, you do get dividends. And when you purchase shares for a particular company, you are given a share certificate. And that share certificate will, of course, reflect the number of shares that you have, the class of shares that you have, for that particular company. So shareholders, like I said, they differ quite a lot from directors. So when it comes to directors, the duties of directors are regulated quite extensively in the Companies Act, which is possibly one of the most important laws or piece of legislation when it comes to companies. So the Companies Act is quite extensive in various principles when it comes to companies. So you know what a company is, the various types of companies you can open, the duties of directors, the limitations of directors, the shareholders, the various classes of shareholders, and a host of other topics that the Companies Act deals with. So when it comes to directors, there are limitations in the Companies Act on the powers of particular directors. There are also prohibitions on what directors are prohibited from doing. So I think it's important that when you open up a company, you are mindful that the duties of directors are extensively regulated in the Companies Act. So what you may or may not necessarily be able to do may be regulated as a director. So I do think it's quite important that when you do choose directors for a particular company, you choose people who understand what it means to be a director, and that the roles and responsibilities of directors are actually regulated and important. Of course, if you are non-compliant with your duties as a director, you can actually be declared a delinquent director. So when it comes to directors, always try to ensure that you are electing people who understand what it means to be a director and who understand the prohibitions or the limitations that come with duties of directors, and of course understand the role of the director or the purpose that the director has for a particular company.